Welcome back. As we mentioned this afternoon, the House voted to end the record-setting 75-day shutdown of the Department of Homeland Security, passing the Senate-approved bill to fund most of DHS except for ICE and Border Patrol. The Republicans now plan to try to fund those two agencies without Democrats. Last night, the House adopted a Senate budget resolution to begin that part of the process. And today, the Speaker celebrated both of those votes. Listen.
This will relieve pressure from the Department of Homeland Security. Secretary Mullen, who I've spoken to in the last couple of hours, will be greatly relieved. The President will, the administration will. We were not going to have lines at TSA. Everybody will get their paychecks now. We'll get moving forward. And then we will finish the work and finally get, again, for 3 years, with no crazy Democrat reforms, we will fund Border Patrol and immigration enforcement as soon as we return for the work session when that bill is finalized.
Joining me now is NBC News Capitol Hill correspondent Melanie Zanona. Mel, thanks so much for being here. So walk us through how the House got here. Why didn't they pass this bill weeks ago when the Senate bill initially passed?
What's happening, folks? Dr. John here. So what just happened, guys? Congress has voted to permanently bar Donald Trump from holding any federal, state, or local office using Section 3 of the 14th Amendment, crafted after the Civil War, to prevent oath-breaking insurrectionists from reclaiming power. It's an unprecedented constitutional action that could fundamentally reshape American democracy. For over a century, Section 3 lay dormant. It was a constitutional curiosity that scholars discussed in history classes and law review articles. It was an academic footnote, a reminder of a distant era when the nation had to confront the reality of former Confederates trying to return to power. But now, in an absolutely stunning development that has sent shockwaves through every corner of the political establishment, Congress has invoked this provision against a sitting and former president of the United States. This is the most consequential application of that constitutional provision in American history. Are you kidding me?
Yeah, it is a great question, Kristen. There's been a lot of acrimony between House and Senate Republicans over their DHS funding strategy. And just to rewind a little bit here, the Senate initially passed a version of this exact same bill back in the end of March. The very next day, we thought the House was going to pass it, but House conservatives and Republicans balked. They refused to pass it. It took another few weeks for Speaker Mike Johnson to finally commit to putting this bill on the floor. So the Senate repassed it, sent it over to the House. That was on April 2nd. And yet Johnson still refused to put it on the floor. The reason is because conservatives had a major issue with voting for a bill that did not include funding for ICE, for immigration, for Border Patrol. And so what changed this week are really two things. Number one, the White House put some renewed pressure on House Republicans to pass this bill. And number two, the House and Senate both did take concrete steps to set up a process that is going to enable them to fund ICE and Border Patrol through reconciliation. That's a party line process that does not require Democratic votes. But certainly there are questions in the Capitol today, questions we asked of the Speaker of why they couldn't have just passed this a month ago, saved a lot of heartache, saved a lot of these employees from the pain of not knowing where their next paycheck is coming from. Just another example of how these shutdowns have really become the norm on Capitol Hill.
The 14th Amendment clause, written in 1866 for the aftermath of the Civil War, has just been used to permanently bar Donald Trump from ever holding office again. The constitutional machinery designed to keep Confederate officials from returning to power has just been deployed against a 21st century president. Now let me make something crystal clear before we go any further. This congressional vote did not materialize out of thin air. It is the product of a legal and political process that has been building for years. This process has involved 2 impeachment attempts, multiple legislative proposals, a Supreme Court decision that clarified exactly which institution has the authority to enforce Section 3 disqualification against federal office holders and candidates, and a documented record of Trump's conduct around January 6th that dozens of constitutional scholars and hundreds of lawmakers concluded met the legal standard for insurrection, as the 14th Amendment uses that term. Let me walk you through the timeline that led to this historic moment. Back in late 2022, a group of House Democrats introduced legislation explicitly invoking Section 3 to bar Trump.
You're absolutely right about that. Just to remind folks, at the root of this was Democrats saying they would not spend a penny for ICE and CBP. So as you say, Republicans are going to fund those agencies without Democratic support. Who are the political winners and losers at this point, Mel?
I think both parties are going to say that they came out victorious in this process. Democrats and Republicans, they really did try to come to an agreement initially before all of this on some reforms to ICE and to immigration. They weren't able to come to an agreement, but we did see some significant changes in the way the administration is conducting its immigration operations, from ousting Kristi Noem, who was leading DHS, to agreeing to more body-worn camera funding for body-worn cameras for these ICE agents who are out in the fields. But Republicans have made the point that now that they've decided to go it alone on ICE funding and Border Patrol, they're not going to need Democratic input. And in fact, they are planning a process that would actually fund those departments for 3 years without any Democratic votes. So that's what we're expecting to see next. Trump wants that bill on his desk by June 1st.
From future federal office, they argued that his role in the January 6th attack and in the broader effort to overturn the 2020 election met the constitutional standard. That legislation was the first formal congressional move to use the 14th Amendment enforcement mechanism against Trump. It was a warning shot, a signal that the constitutional tools existed and that there were lawmakers willing to use them. Then came the Supreme Court's intervention. In a ruling that would prove to be far more consequential than anyone initially understood, the court held that states cannot on their own keep Trump off presidential ballots under Section 3. The court made clear that Congress has primary authority to enforce the disqualification clause against federal office holders and candidates. The Supreme Court effectively told the entire country that if Section 3 is going to be applied to Trump, the institution that has to do it is Congress. And now Congress has done it. Here is the context that makes this specific vote the culmination of a process that has been building across multiple institutional channels simultaneously. The January 6th committee spent 2 years building the evidentiary record. They interviewed hundreds of witnesses. They reviewed thousands of documents.
Without objection, the motion is adopted.
By a vote of 217 to 214, the House narrowly passed a funding bill to end the partial government shutdown Tuesday.
I'm happy to report Republicans got the job done. Our majority worked together, and we got the bills over the line.
The legislation includes 5 full-year spending bills and only a temporary funding extension for the Department of Homeland Security, as Democrats demand reforms to immigration enforcement policies following federal agents fatally shooting 2 Minneapolis residents.
Body cameras must be required by law, and masks must come off. Judicial warrants are a requirement, not a suggestion.
President Trump signed the legislation shortly after it passed. Now that the measure has passed, Democrats will have less than 2 weeks to reach a deal with Republicans about reforming ICE before funding for Homeland Security runs out.
Kristi Noem must go.
Ahead of the vote, 22 House Democrats protested outside ICE headquarters, calling for Homeland Security Secretary Kristi Noem to step down and ICE be dismantled.
The presence of ICE in our communities is not about public safety. This is about stoking fear, silencing peaceful dissent.
On Monday, Noem announced that the department is deploying body cameras to every officer in the field in Minneapolis.
They constructed a detailed and devastating timeline of what happened before, during, and after the attack on the Capitol. The criminal cases built the legal record. The civil cases built the liability record. The congressional oversight investigations built the institutional record. All of that accumulated work was building toward a moment when the political will and the constitutional mechanism to act could come together in the same place at the same time. That moment is now. The 2 impeachment attempts came before the full evidentiary record was available, and before the Supreme Court had clarified which institution has primary authority over Section 3 enforcement. They came when the political will in the Senate measured against the 2/3 threshold for conviction was not sufficient. The Section 3 enforcement action that Congress just passed does not require 2/3 in the Senate. It requires a simple majority in each chamber. The combination of the developed evidentiary record, the Supreme Court's clarification about congressional authority, and the political will that has now coalesced around the Section 3 enforcement mechanism has produced a vote that the earlier impeachment attempts simply could not produce. The constitutional machinery has now been calibrated to the circumstances, and it has just produced the most consequential disqualification action in American political history since the post-Civil War period. Now, I want you to understand the full constitutional mechanics of what just happened, because this is not just about one person. person. This is about how the Constitution actually works when the most serious threats to democratic governance emerge. Section 3 of the 14th Amendment states that no person shall hold any civil or military office under the United States who previously took an oath as a member of Congress or as an officer of the United States to support the Constitution and afterward engaged in insurrection or rebellion against the same or gave aid or comfort to the enemies thereof. The text is remarkably straightforward. It bars from office people who swore a constitutional oath and then engaged in insurrection or gave aid and comfort to enemies of the United States. The provision was written in 1866 as part of the post-Civil War Reconstruction of the constitutional order, specifically to prevent former Confederate officials from simply returning to federal or state office after the war ended. It was not written specifically for any future scenario. It was written to encode a principle. The principle that people who take an oath to support the Constitution and then use their position to work against the government that Constitution creates should not be permitted to come back and hold power. That principle did not die when the immediate post-Civil War period passed. It is still in the Constitution. It is still constitutional law. And Congress has now invoked it against a president whose conduct in the weeks and months before January 6th and on January 6th itself constituted what a congressional majority has determined as engagement in insurrection against the constitutional order. Let me be absolutely clear about something. The provision that was written to prevent Confederate officials from returning to power after the Civil War has just been applied to a 21st century president who sent his supporters to the Capitol to stop the certification of an election result. The historical resonance of that application is extraordinary and cannot be overstated. Now let us dive into the two mechanisms Congress has available for enforcing Section 3 and which one it has used, because the specific mechanism matters enormously for understanding the legal durability of this vote and what challenges are likely to follow. The first mechanism is impeachment and conviction combined with a separate disqualification vote. After the second impeachment trial, a majority of senators voted to convict Trump, but they fell short of the 2/3 required. Because he was not convicted, the Senate never reached a separate disqualification vote. If conviction had occurred, a simple majority vote in the Senate could then have barred Trump from future office permanently. That path was not available after the acquittal. The second mechanism is the one that has been used in the current congressional action. Section 5 of the 14th Amendment gives Congress the power to enforce all of the 14th Amendment's provisions through appropriate legislation. That enforcement power includes the power to pass statutes applying Section 3's disqualification to specific individuals or categories of conduct. Congress can legislatively enforce the insurrection disqualification clause by passing a law that declares a specific individual to have engaged in insurrection and therefore be disqualified from office. That is the mechanism the current vote has used, and it has specific advantages over the impeachment path. It requires only a simple majority in each chamber rather than 2/3 for conviction. It does not require a separate disqualification vote after conviction because the legislative disqualification is the action itself. And it creates a statutory record of the congressional finding that can be enforced through the courts as implementing legislation under the 14th Amendment. Are you kidding me? Congress found a constitutional mechanism that does not require the 2/3 threshold that the Senate acquittal protected Trump from, and used it to accomplish what 2 impeachment attempts could not. That is a significant constitutional development that is going to be argued about in courts and law schools for decades. Now let us talk about the Supreme Court's ruling and why it actually clears the path for what Congress just did, rather than blocking it. Because some people have been claiming that the Supreme Court's ruling somehow settled the question in Trump's favor. It did not. The court held that states cannot unilaterally enforce Section 3 against federal candidates or office holders because enforcement of Section 3 against those federal actors requires congressional action. The court did not hold that Section 3 cannot be enforced. It did not hold that Trump did not engage in insurrection. It did not hold that the disqualification clause is unenforceable. It held that the enforcement has to come from Congress rather than from individual states making their own Section 3 determinations. That ruling is actually the roadmap for exactly what Congress just did. The court says states cannot do this. Congress can. Congress just did it. The ruling is not a barrier to the congressional vote. It is the constitutional blueprint that told Congress it had to act if Section 3 was going to be applied. And now Congress has acted in precisely the way the Supreme Court said was the appropriate and constitutionally valid mechanism for this kind of enforcement. This is wild, like genuinely wild, because the Supreme Court's ruling that was being cited by some as protecting Trump from disqualification actually clarified the path by which Congress could constitutionally accomplish it. And Congress walked that path. Let me be very specific about what the Supreme Court ruling actually said, because it is going to be central to every legal argument that follows this congressional action, and it deserves to be understood precisely. The court was unanimous in its judgment, but not in its reasoning. The majority held that states cannot on their own enforce Section 3 against federal candidates, and that only Congress has the authority to do so for federal office holders and candidates. That is the holding. The court did not address what Congress can do when it does enforce Section 3. It did not hold that Section 3 is not applicable to Trump. It did not hold that Trump did not engage in insurrection. It did not hold that the congressional enforcement mechanism is limited in ways that would prevent what Congress has now done. All of those questions are open questions that the ruling explicitly did not decide. The court said states cannot do this and Congress can. Congress just did it. And the questions the court left open are now the questions the next round of litigation is going to answer. Legal scholars who have read the ruling carefully have noted that it actually invited and enabled exactly this kind of congressional action. The Supreme Court gave Congress a roadmap, and Congress followed it. That is not an abuse of the constitutional process. That is the constitutional process working as the Supreme Court said it should work. Now let me put the January 6th foundation of the congressional finding in context, because it is the factual basis for the insurrection determination, and it deserves clear and explicit attention. The congressional record of what happened on January 6th and in the weeks before, it is extensive, documented, and based on the work of the House Select Committee that spent years gathering testimony, reviewing documents, and building a factual record of what occurred. That record shows a president who was told repeatedly that his election fraud claims were false, who was told that his legal challenges were failing in court after court because they were not supported by evidence, who nonetheless continued to advance those claims publicly, a president who pressured the vice president to refuse to certify the election results, who pressured state officials to change their state's certified election results, who directed his supporters to march on the Capitol and fight like hell, who watched for hours as the Capitol was attacked, and who declined to act to stop it despite desperate pleas from allies and family members. That is the factual record. The congressional insurrection finding is based on that record. The constitutional standard for Section 3 does not require a criminal conviction. It requires engagement in insurrection, a determination that Congress has the authority to make through its enforcement powers under Section 5 of the 14th Amendment. The congressional majority that voted to bar Trump has made that determination based on the documented record. And that determination is now a formal congressional finding that is part of the permanent legal record of this moment. The documented evidence of what happened is what the 14th Amendment's insurrection clause was written for. Congress has now said so formally. Let me address something that is going to be said loudly and persistently by Trump's supporters, and that deserves a direct and honest response. They are going to say that using the 14th Amendment to bar Trump from office is an undemocratic action that overrides the will of the voters who elected him. They are going to argue that voters should decide whether Trump should hold office again rather than Congress. And they are going to frame the congressional disqualification as an elite political class using constitutional machinery to override a democratic mandate. That argument has emotional resonance for a lot of people, and it deserves a direct response. The 14th Amendment and its insurrection disqualification clause are themselves products of democratic action. They were passed by Congress and ratified by the states through the democratic amendment process. The principle that people who swear oaths to the Constitution and then engage in insurrection should not hold power again is itself a democratically enacted constitutional principle. The question is not whether democracy gets to decide. Democracy already decided when it ratified the 14th Amendment. The question question is whether the conduct met the constitutional standard that democracy established. Congress has answered that question, and the courts that evaluate that answer are also democratically accountable institutions. What Trump supporters are really arguing is that their preferred outcome should override the constitutional process. That is not an argument about democracy. It is an argument that this specific person should be exempt from the constitutional rules that apply to everyone else. The 14th Amendment exists precisely to refute that argument. Let us now break down why this congressional vote is so significant and what it means for the country going forward. The congressional vote to bar Trump under the 14th Amendment is the first successful use of Section 3's disqualification mechanism against a federal officeholder in the modern era, and it creates a constitutional precedent that is going to define how Section 3 is understood and applied for generations. Here is why the precedent matters beyond the immediate question of Trump's eligibility to hold office. Before this vote, Section 3 was a constitutional provision that scholars knew existed, but that had never been applied to a major modern political figure through a complete and successful congressional enforcement action. Its application was theoretical. The debates about whether any specific conduct constituted insurrection under Section 3 were academic. The constitutional mechanics of how Congress would enforce it were discussed in law review articles rather than enacted in legislation. All of that changes today. Congress has now made a formal institutional finding through the constitutional mechanism that the Supreme Court identified as the appropriate one. They have determined that specific conduct by a specific individual constituted insurrection, and that the constitutional disqualification applies. That finding is now a living, breathing application of constitutional law rather than a theoretical possibility. Every future politician, every future official, every future person who takes a constitutional oath and then considers taking action against the democratic order knows that the Section 3 mechanism is real, is operative, and is available to Congress in circumstances that meet the constitutional standard. The 14th Amendment just got activated in the most consequential way since Reconstruction, and the precedent it sets is going to last far longer than any individual political career. Now let us talk about the legal challenges that are going to follow this congressional vote, because they are going to be significant, and they are going to define what Section 3's enforcement looks like in practice. As the courts evaluate the constitutionality and the scope of what Congress has just done, here is what those legal challenges are likely to focus on. Trump's legal team is going to argue that the congressional enforcement action under Section 5 exceeds Congress's authority because Section 5 requires legislation that is congruent and proportional to the constitutional violation being addressed, and that a permanent bar from office for one specific individual goes beyond what proportionality requires. They are going to argue that the insurrection finding itself is unconstitutional because it deprives Trump of due process by making a criminal-type determination without the procedural protections of a criminal trial. They are going to argue that the Supreme Court's ruling was broader than it appears, and that it limits the enforcement mechanisms available to Congress in ways that the current legislative action exceeds. Those arguments are going to get a hearing in federal courts. Some of them may have enough merit to reach the Supreme Court. And the Supreme Court, the same court that told Congress it was the appropriate institution to enforce Section 3, is going to have to decide how far that enforcement authority actually extends and what procedural requirements attach to its exercise. The constitutional litigation that follows this vote is going to be as significant as the vote itself. And the Supreme Court's answers to the questions it generates are going to complete the constitutional picture of what Section 3 enforcement in the modern era actually looks like. That picture is still being painted, but Congress just added the most important stroke. Now consider this dimension of what has happened. The congressional vote to permanently bar Trump from office is a formal institutional declaration by the elected representatives of the American people that the conduct surrounding January 6th constitutes insurrection, and that the constitutional consequences of insurrection apply to the person who engaged in it. That declaration is now permanent. It is in the congressional record. It is formal legislation legislation under the 14th Amendment. It cannot be undone by a presidential pardon. It cannot be reversed by the result of any election. It can be challenged in courts, and it may be modified or overturned by judicial decision, but as a statement of congressional judgment, as a formal expression of what the legislative branch of the American government has found about the conduct of a former president, it is a document that is going to be read and analyzed and debated for as long as American political history is studied. Its significance goes beyond Trump specifically. It says that Section 3 is a living constitutional provision that can be applied when conduct meets its standard. It says that Congress takes seriously its constitutional obligation to enforce the protections the 14th Amendment established against the return of insurrectionary actors to power. And it says that the American constitutional system has institutional tools to respond to the most serious threats to democratic governance, and that those tools will be used when the evidence and the constitutional standard are met. The 14th Amendment was written by people who had just watched their country nearly destroy itself over a conflict about power, loyalty, and who gets to hold authority in a democratic republic. They knew from direct and devastating experience what happens when people who swore oaths to the Constitution use those oaths as cover for attacking the constitutional order itself. They wrote Section 3 to ensure that the lesson of that experience would be encoded in the Constitution itself, not as a principle that future generations would have to rediscover, but as a binding rule, as a constitutional requirement that anyone who engages in insurrection against the government they swore to support cannot come back and hold power over that government again. Congress has now applied that rule in the most significant and most public application of Section 3 in the modern era against a former president who a congressional majority has determined met the constitutional standard for the insurrection disqualification. That application is historic. It will be challenged. It will be litigated. The courts will have the final say on whether the congressional action was constitutionally valid and whether it will be enforced. But the vote itself is a permanent part of the record. The constitutional declaration is made, and the principle the 14th Amendment encoded over a century and a half ago has now been invoked in the most consequential possible context. Here is what you need to carry with you as you process what just happened. The federal judiciary is not the only institution designed to be a check on concentrated power. Congress, through its enforcement powers under the 14th Amendment, has now demonstrated that it too can serve as a constitutional backstop when the most serious threats to democratic governance emerge. Presidents come and go. Political movements rise and fall, but the Constitution endures, and the Constitution has now spoken through its democratically elected representatives in a way that will echo through American political history for generations. The vote may not be what Trump wanted. The outcome may not be what his supporters hoped for, but this is exactly what the Constitution's framers envisioned when they wrote Section 3. This is exactly what the Reconstruction Congress intended when they drafted the 14th Amendment. This is what constitutional governance looks like when the institutions function as designed. Stay tuned, because next time we are going deep on the specific legal challenges to the congressional disqualification action that are already being filed and what constitutional scholars say about which arguments have the most realistic chance of succeeding in the federal courts that are going to evaluate them. You do not want to miss that one, because the legal challenges now coming will produce critically important and historic rulings about the 14th Amendment that will shape American democracy for decades to come. The cases in the pipeline are going to be just as significant as the vote itself, and the overall constitutional picture will only become clearer as the courts weigh in on what Congress has just done.